Hello and welcome to today's webinar, the 2025 Tariffs, Framework, Facts, and Forecasts. Thank you for joining us. My name is Dave Noah and I am founder and president of Shipping Solutions. Since 1995, our export documentation and compliance software has helped thousands of successful exporters more efficiently generate accurate export documents and stay compliant with import-export regulations. To help educate our customers and the wider international trade community, we regularly host free webinars like this one on the various aspects of international trade. Today we are very lucky to have Adam C. Lee as our speaker. Adam has practiced in international trade disputes in every aspect of import trade and customs laws since he first joined Harris Sliwoski in 1995. In addition to concentrating on trade remedies such as anti-dumping and countervailing duties, his areas of practice also include customs, foreign investment, international business operations, financial planning, and intellectual property. His cases involve clients in Canada, China, Hong Kong, Indonesia, India, Japan, Kazakhstan, Malaysia, Mexico, Saudi Arabia, Singapore, South Korea, Taiwan, Thailand, Uzbekistan, Vietnam, and the United States. He has represented multinational clients in industries such as semiconductors, chemicals, steel, plastic, automobile parts, and consumer, agricultural, and textile products. So we're very lucky to have him with us today.
David, thank you very much. Happy to be here and talk about tariffs there. When President Trump won the election last November, I think there was a consensus that tariffs were going to be heading our way. But now that we're just over 100 days into his second term, I don't think anyone realistically expected, how many and how broad the tariffs that have been issued. So today I'd like to just provide an overview of where are we with all the tariffs, both from the first term and the flurry of all the tariffs that have been more recently announced. I'll discuss the legal basis for the different tariffs and how that affects how they've been imposed. Given the limited time that we have, this is going to be just a quick highlight of the main tariff events and is not intended to be a comprehensive review of all the tariffs. Hopefully nothing breaks on tariffs as we do this webinar, but you never know. After that, I'll go into some of the ways that companies have been trying to deal with the tariffs. I'll discuss how a lot of companies are starting to look at country of origin, classification, valuation, all as possible ways to mitigate the tariff impact, and more importantly, how to distinguish legal and illegal ways of handling those issues. And then finally, I'll offer my 2 cents on what we can expect from this second wave of tariffs. And I'll give you my best case and worst case scenarios. And then after that, hopefully we can open the floor to questions and address anything that's on your mind with tariffs. From the first term, the ones that jumped out were the Section 201, Section 232, Section 301 tariffs. The big ones were Section 301. So those were mainly the China tariffs. They were the reasoning for those China tariffs was to stop China's illegal intellectual property practices. He also initiated a bunch of Section 301 investigations on digital service taxes on 11 different jurisdictions, so a lot of European countries. The Section 301, they were special in the sense that you don't need to make any findings of unfair imports or injury. You just say, I want to impose these tariffs because we find that there are certain acts, policies, or practices of a foreign government that are unreasonable or discriminatory, and they burden or restrict U.S. commerce. And that's, the legal basis for imposing those tariffs. And this is different from other tariffs like the Section 201, which are safeguard tariffs, and they were imposed on washing machines and the solar modules, solar cells there. In those instances, you have to find serious injury caused by the imports as a justification for those imports. The legal process of applying those tariffs, there is a process in which the government has to give notice of the tariffs that are coming in. They have to give people a chance to comment on, whether the tariffs are good, bad, whether they should be limited to particular products. But there's an opportunity for people to weigh in on how the tariffs should be imposed. Now, all of the tariffs from the first term had some type of notice and comment period. And, so that's important to note because, as we'll see from the current terms wave of tariffs, most of them have not had that notice and comment period. So that's why the tariffs of this term are significantly different just because of how they've been rolled out without any notice and comment period. They've just been dropped by executive fiat. So the big tariffs from the second term, the biggest difference is President Trump's use of IEEPA, the International Emergency Economic Powers Act. And that coupled together with National Emergencies Act, that's the legal basis for President Trump issuing a significant part of the tariffs that have been issued so far. The two main areas that he's issued under IEEPA are the fentanyl slash immigration tariffs. He's targeted China for those, first with 10, followed up by another 10, so that's 20% for China. And then he announced that Mexico and Canada are also involved on the fentanyl immigration crisis, so he proposed 25% tariffs on them for that. He quickly backed off on the Canada-Mexico tariffs, but then within that period, he also announced his reciprocal tariffs. The reciprocal tariffs, he first imposed a 10% tariff that applies to all imports from all countries. And then he also announced a range of tariffs up to 50% on about 56 countries that are listed in the Annex 1 of that executive order. He listed a handful of exclusions for a number of HTS categories for products that will not be hit with tariffs, but it's a very limited number. Those are the Annex 2 exclusions. So there have been some challenges that have been filed against the IEEPA tariffs there. And that's a lot of the legal challenges that have been filed are focusing on the legal basis for IEEPA. The key language under IEEPA is whether there is an unusual and extraordinary threat that needs to be responded to by the president's actions there. The president has basically said the trade deficit is a national emergency that affects the U.S. economy. But the legal challenges have basically noted that, look, the U.S. has run a trade deficit going back to the 1970s, so it's really not that unusual. Another argument is that, given how he's, first imposed the tariffs, but then he's paused them, if the tariffs are really, that if the emergency is that critical, then the on-off nature of imposing these tariffs, it kind of belies the significance of that threat. And then the other another argument is, you know, do the tariffs really have any causal nexus with the declared emergency? Because if there is an emergency that needs to be solved, how do tariffs actually address that emergency? Do the tariffs actually will they actually help the trade deficit? Will they actually help the fentanyl/immigration crisis there? And so the arguments there are focusing on how the tariffs really, at best, are an indirect measure that respond to the declared emergency, and more likely they have no causal relationship to the actual emergency that's being offered as the excuse for the tariffs. Another argument is the fact that IEEPA doesn't actually say that the president can impose tariffs or taxes. And this is significant because there's a constitutional argument that Congress was given the powers under the Constitution to impose taxes and tariffs, and that the executive branch is overstepping the constitutional basis by unilaterally imposing tariffs without the consent of Congress. Another argument is the major questions doctrine. This is basically whether executive action can be taken of economic and political significance without the approval of Congress. The Supreme Court basically rejected President Biden's the plan to cancel out student loan debts, and they used the major questions doctrine and noted that the cancellation of the student loan programs would have had a $500 billion impact on the national economy. And so with that type of reasoning, it's not hard to imagine how the impact of the tariffs would also have similar range of economic impact, many hundreds of billions of dollars of impact. So, people are raising the major questions doctrine as another way of possibly challenging these IEEPA tariffs. And then by the terms of the IEEPA statute as well, IEEPA, the president has to every 6 months, give a notice to Congress saying, where are we with this emergency? Likely he'll just say, yep, the emergency's still on and we have to continue. But the IEEPA language, statutory language says it will automatically terminate unless the president gives notice at least 90 days before the anniversary saying that he needs to continue. So, the way IEEPA is working is, if the president says that it's an emergency, it is an emergency, and that gives him enough authority to move forward with it. So, based on President Trump's say-so as to what is an emergency, that is essentially why we have all these tariffs right now. But in addition to those IEEPA tariffs, we still have a bunch of other tariffs that he's rolled out. On Section 232, the national security tariffs, he's went back to the old steel and aluminum tariffs, and he eliminated a bunch of the exclusions and exemptions that had been granted. And so basically all the steel and aluminum products that were originally covered are now subject to 25% tariffs. He's initiated a bunch of 232 investigations on copper, lumber and timber, pharmaceutical products, semiconductor machineries, auto parts, critical minerals such as rare earth metals. All of those have been initiated and look like they're headed towards more tariffs on those particular products. Just yesterday or earlier this week, he announced that he wanted to impose tariffs on movies, 100% tariffs on movies. So um, everything is, a potential target for Trump's tariffs at this point. He's also initiated Section 301 investigations on Chinese semiconductors industries, their dominance of the semiconductor industry, the maritime shipping industries. He's even initiated 301 investigations in Nicaraguan labor and human rights practices. Another tariff measure, it isn't specifically a tariff, but he's eliminated the de minimis exception. Basically, under customs laws, if the value of your goods was less than $800, you didn't have to file a customs return. So you could be exempted from filing any customs entries and therefore didn't have to pay any normal duties or be subject to any of the tariffs. He's even gone so far to announce secondary tariffs. So it's not just on imports that are coming in, but he's now saying, like, if you are a purchaser of Venezuelan oil, we're going to impose tariffs on you. And he's even proposed that, if you're buying Russian oil, he's threatened tariffs on purchasers of those. So it's not just, someone who's actually importing product. He's going to an indirect purchaser of those products. So then, turning to how companies are dealing with all of this tariff madness. People are trying to look at, well, can I change the country of origin if I'm sourcing from China now that they're at 145%? Can I get my products to be a non-Chinese origin because, other countries will only be at, say, 30% or 50%, they see that as relatively better than being from China. So they're looking to see, can I change it? Some people are just, doing the quick and dirty way of just transshipping their products. They're shipping them from China. They may reroute them to another port in Southeast Asia through Malaysia, Indonesia, Vietnam, anywhere, and then they'll just, stick another label on them, or they'll just declare them as country of origin from, Vietnam as they enter the U.S. Now, that is a, flat out illegal, false country of origin declaration, and that will get you into trouble with U.S. Customs and Border Protection. Um, you know, there is a significant amount of CBP crackdown trying to enforce the customs laws, and they are very sensitive to folks trying to evade these tariffs by making false declarations on the country of origins. Now, there is a legal way to change the country of origin. You can take Chinese parts and use them in a new manufacturing operation in a third country. As long as those Chinese parts are processed and are substantially transformed in that third country as a result of that processing, as long as it changes into a new product that has a new name, character, and usage, that is good enough to earn a new country of origin. And so that's what a lot of companies are trying to explore. It's like, what do we need to do to, change our production operation so that we can get a substantial transformation and get our products out of China and have a new country of origin. The other way, not so much with the current round of tariffs because they're so broad and they're on a countrywide basis, but under the old tariffs, they were looking at classification because the first round of tariffs were looking at specific products that were classified under specific HTS codes. So there were a bunch of HTS codes that weren't subject to tariffs, and so people were trying to figure out, well, can we change our product in a way that can be so that it can be classified under a different HTS code that isn't subject to tariffs. So folks were trying to, you know, figure out what can we rename our product. Now, some folks were just, taking steel plates and calling them turbine parts or wooden bedroom furniture and calling them non-bedroom furniture just to avoid the tariffs. But they really didn't have any, factual basis, legal basis to do that. And so that's a illegal misclassification that, CBP would basically crack down on if they could get a chance to. Now, there also is a legal way for customs to sign off on the classification. Customs does issue rulings, pursuant to requests that say, "Hey, how do I classify this?" You can propose. We think that this HTS number is the appropriate classification for this product, and then customs will issue a binding ruling saying, "Yes, we agree," or "No, we don't. We think this other HTS number is the right one." And that is a binding ruling from customs on them and on that you can use to safely classify your products. The other way people are trying to mitigate the tariff impact is looking at valuation. Can they reduce the value of their products so that instead of having $100 product there, and tariffs being imposed on $100 product, saying, can we reduce that value so that instead of, paying it on $100, we declare the value at $90 or $80 or even lower. So um, some companies are taking it to the extreme and they're just, declaring something that's, totally unrealistic. If the real value is 100, they're saying that the value is actually 15. Um, Others were trying to get under the previous $800 de minimis value there to try to avoid any customs declaration. But that option has now been removed because they've eliminated that de minimis exception. Now, there are ways to legally reduce your value. The key is just to make sure, are you actually declaring the transaction value of the products that you're importing? And that's defined as the price actually paid or payable for that product. And that the key issue is, are you capturing everything that is in that price? And that includes any assists. Assists are tools, dies, molds, materials, components, anything that is helpful to produce that product. That can include engineering, artwork, designs, um, and so those are ways that people are trying to, figure out, are there ways that we can break out certain costs and try to have those paid separately, not on a product specific basis, but on a broader basis so that we can reduce our per unit prices there. Turning next, people are asking me, well, what's going to happen with all these tariffs? And my crystal ball is probably just as cloudy as everyone else's, but my, my best case scenario for the tariffs is that uh, President Trump declares wins for some of these tariffs, and he, will lift those tariffs, or at the very least, he'll suspend them so that he can continue to negotiate them, and he'll sort of buy time and sort of use the tariffs as some leverage to keep them hanging over the various countries until he gets a deal that he is happy with. Um, and so the tariffs, hopefully, in that scenario, won't be imposed, but they'll just kind of be lingering as a threat of a tariff that could be imposed. Another hopeful scenario is that um, there'll be enough of a cry from domestic manufacturers who want to produce in the US, but are in desperate need for certain imports that can't be sourced from domestic or any other sources. And President Trump will realize maybe we do need an exclusion request process so that certain products can be excluded from the tariff so that they can help U.S. manufacturers. Another option is hopefully Congress will um, take a little bit more action to reclaim their trade authority. Going back to the Clinton administration, Congress basically handed over the trade authority and gave the executive branch extreme authority over international trade matters. But basically, President Trump has taken that executive authority on trade matters to an extreme with all of his tariff actions. So hopefully Congress will try to, reclaim some of that trade authority and rein in the presidential authority. And then people are saying, well, at least hopefully, this will all end by 2028 if and when the Democrats reclaim the White House. But it's significant to note that President Biden did absolutely nothing to withdraw any of President Trump's tariffs from the first term. In fact, President Biden did impose even more tariffs on China and other products during his term. So traditionally, Democrats have been more protectionist than Republicans. It's odd now that in our politically divisive climate now, trade and being anti-China on trade matters, that's become one of the very few issues in which both Democrats and Republicans do agree upon that they need to be more aggressive against China, particularly on trade matters. So that's my best case scenario. The worst case scenarios are that we're 100 days in and we've got many more days to go in Trump's tariffs, and there's a likelihood of more tariffs that are going to be added. We've got first all the reciprocal tariffs that have been paused for 90 days, and that pause period is coming to an end soon, and maybe he's just going to impose those tariffs back on, put them back on again. Canada and Mexico have a temporary reprieve. Anything that's USMCA eligible is exempt from the tariffs, but maybe he'll change his mind on that again. Basically, anything from any products from any countries are a potential target, and it's just it seems likely that he could change his mind and decide to impose tariffs on a whim on anything going forward. And the other issue with tariffs are that tariffs are taxes, and taxes are very sticky. It's very it's much easier to impose a tariff than it is to get rid of a tariff. And so the concern is that once tariffs are in place, it's going to be harder to get rid of them. Theoretically, you can issue an executive order to lift the tariffs just as easily as you can issue an executive order imposing them, but so far we haven't seen any executive orders lifting them. And then the general fear of the tariffs is that it's not so much the tariffs themselves, because over time companies, countries do learn to adjust. Trade is a very resilient industry, right? Trade finds a way. As long as supply and demand, people figure out a way to get supply to meet the demand. The real kicker with the tariffs that is causing people to become very concerned is that it's the uncertainty. Businesses hate not knowing what's going to happen, and just the uncertainty as to where are the tariffs going to be coming from next. How long are they going to be imposed? that uncertainty is causing people to pause on their business planning. Do I want to invest in new machinery? How am I going to um, find new suppliers if I don't know what's my potential tariff impact? So that uncertainty is creating a very dampening effect on both the U.S. economy and the global economy as a general whole. And so, um, you know, we're looking at a potentially very bad economic scenario going forward. And then the absolute worst case scenario is that the trade wars lead to a real war. To the extent that certain countries get impacted by the tariffs to a greater extent, that they get more desperate, that it could trigger other events that have more consequential effects there. Going back to World War II, the trade sanctions on Japan, contributed to Japan's actions to, that eventually led to the bombing of Pearl Harbor. So, there is the potential that the economic tariff impacts can spill over and cause a military war that would have extreme consequences as well. So that concludes my comments there. I'm happy to open it up to questions, and we'll happy to answer any questions you have.
Great. Thanks, Adams. That was very interesting. A lot of information there, a lot of things changing very quickly. So we appreciate that recap. I think to start with, a couple questions related to where people can get real-time information on these changing tariffs. Is there a website with up-to-date real-time tariff rates by country?
There's a number of sites. If you type in tariff tracker, you should come up with a number of sites that give you, some listing of the tariffs. And given that there are so many, you kind of have to look around. Some, listed by chronological order. Some listed by industry, some listed by country. So there's a range of websites that you can try to find the tariff tracker that works for you.
And I don't like to make these very promotional, but Shipping Solutions does have our trade compliance software and an import controls tool, which allows you to enter in an HS code and see what the associated tariffs are with that. And you can sign up for a free trial for that on the Shipping Solutions website. So go to the trade compliance menu choice and sign up for a free trial there. And then has an updated Annex 2 exclusions list been published?
Not yet. I mean, I think just whatever was issued originally with Annex 2, that's currently the list that we're working off of it right now. We're hopeful that others, more HTS codes will get added to it, but not yet.
Regarding to the recent executive order on the prevention of tariff stacking, I'd like to clarify whether the reciprocal tariffs for goods of Chinese origin also stack on top of Section 301 and the IEEPA 20% and the AD/CVD for Chinese goods.
Yeah, no, that's a really good question because the he issued an executive order to eliminate the stacking of some, but not all of the tariffs. And so, unfortunately, the Chinese origin, the Section 301 tariffs, those are not part of this unstacking problem. So you do have the original Section 301 tariffs. Originally, you have the 20% fentanyl tariffs. And you now also have the reciprocal tariffs on China as well. So China's getting hit at three, four different levels there. So, and then if you get into specific products like solar or semiconductors, you've got a fifth or sixth layer to be added on, and sometimes you have anti-dumping duties as well too. So, for certain Chinese products, it's a whole mess out there.
Someone asked, I thought the de minimis exemption was only for China. Am I wrong on this?
Nope. I mean, China was the biggest user of that, with Temu and Shine, and they created whole industries of shipping stuff out under that de minimis industry. But that's for any and all products that are imported in under that $800 exception. Doesn't matter which country it's from.
Someone asked, what is the average cost if you abandon a shipment? I'm assuming that's because the tariffs are too high.
I guess it's the value of the goods that are coming in, right? And plus any of the shipping costs and, anything that you've incurred to deal with it. So I don't know. I mean, it's basically, on whatever your shipment value is there. So I don't know, if there are stats that are tracking, the, abandoned shipments to come up with that average loss number there.
I had a couple or a question for if a company is caught either falsifying their country of origin determination or misclassifying the HTS code of an item or are using the wrong value of an item, what are the penalties for that?
There are both civil and criminal penalties involved. I'll start with the criminal penalties because there are examples where customs will, you know, they will go after you for criminal fraud, and people are going to jail for customs, duty evasion. We see it a lot in the anti-dumping world where you have, anti-dumping duty evasion, transshipment schemes, country of origin schemes, and people are willfully, misdeclaring their products to avoid the duties. And, when they get caught, they are not just getting hit with financial penalties, people are going to jail for that. So it can happen. Um, if you exercised reasonable due diligence as an importer and you have a reasonable basis for claiming the HTS number, but you're wrong and customs says, no, we disagree with you, but we don't think you're correct on this. They'll basically ask you to pay what you should have owed under the right HTS number, but they won't necessarily penalize you. So it's you basically can correct yourselves and pay the difference as to what you should have. So in that instance, the penalties will be you know minimal if any at all. So it does range. It kind of depends on um, you know certain products are red flagged by customs to as higher priorities for their enforcement efforts. Those tend to be under higher scrutiny levels, and so importers, exporters have a higher standard to try to meet and make sure they're not facing higher levels of penalties from customs.
Why would aluminum and steel products fall under national security? Is that due to weaponry? This company exports many aluminum and steel products, so this is affecting their customers.
Yeah, no, the ostensible rationale for the national security argument for steel and aluminum is that the steel and aluminum industry is a very critical part of the U.S. economy, not just for military purposes. That certainly is part of it, but just in general, American steel is important for the American economy. American aluminum is very important for the American economy. So their ability to maintain and protect the American steel and aluminum industries was considered so important to be a national security interest and that's why they imposed the tariffs under Section 232.
Is there any indication of the countries affected by potential secondary tariffs, such as buyers of oil from Venezuela? Have there any examples of where that's been imposed yet?
Yeah, no, it's one of those things where he's talked about it, but we haven't actually seen it happen yet. So, I think the idea is like, well, how's he actually going to enforce that, right? It's like, you know, if he finds out, it's like, oh, you bought, a few 100,000 barrels of Venezuelan oil. Now what? What do we do now? So no, it's one of those things like, well, he's announced this, so how's he actually going to carry this out?
If substantially transforming, if they're substantially transforming materials, do they have to declare the country of origin to be that of the main component in the finished good? For example, if all Chinese materials sent to India to be substantially transformed into a finished good, then isn't the country of origin still China?
Yeah, no, the way the country of origin analysis works is that customs looks at the product as it crosses into the US. So what is actually being imported? So that's the question is what is the country of origin of that product being imported? The analysis then works backwards from there. It's like, okay, how was that product made? And then you go in to see, well, what are all the various parts that went into it? Where did those parts come from? If they all came from China and they were just simply kind of, assembled with very minor assembly operations, nothing terribly complex, they're basically saying, look, that's essentially an all Chinese input, a product made from only Chinese imports, and you're really not adding much value in India. So we're going to count that as really a Chinese product. But if in India you're actually doing something pretty sophisticated and you have to do a lot of fine tuning and you're combining it with a lot of non-Chinese components and you're creating a new product that's very different from the Chinese inputs, that may be enough, to create a substantial transformation. So it's there's no simple formula to know what's a substantial transformation or not. You basically have to look at each product, each manufacturing process, and try to evaluate it on a case by case basis.
Can that change based on the tariff heading of an item, or is that the same for all items across the board?
Yeah, there one way of seeing if there's a substantial transformation. Some countries use a tariff shift method. It's like so if the input comes in under one HTS code and it's processed into another finished good that comes out with a different HTS code, that tariff shift is a signal that that's a substantial transformation. The U.S. doesn't use that tariff shift system for most of its substantial transformation analysis. It uses it as part of its USMCA NAFTA analysis in part, but for most products it does not.
So when we're looking at what the real value of an item is that the value of what was paid by the company importing the good into the United States, or what you're selling the product to the final customer is?
What the importer is paying to the foreign supplier, that's the price actually paid for the imported good. That's what customs would be looking at. The resale value, that can be a reference point as to test the validity of the transaction value that you're declaring, but that's usually not the primary concern of customs.
We are a small company in Massachusetts that imports Christmas ornaments and figurines from Mexico. We've never paid duty on our imports until the recent 25 tariffs on goods from Mexico were levied. The ornaments are 100% made in Mexico of Mexican components. We have been told that we are no longer exempt from a tariff. We're confused on this because our understanding was that under the USMCA, as long as the country of origin was Mexico, we would not be charged. Do you have any thoughts or additional information on this?
I mean, based on that, it seems like that should be USMCA origin product there. So, that should be exempt from the tariffs, the way I see it. So I'm equally confused why, they're being hit with tariffs on that one.
Customs ruling HQ H3 12426 and Customs ruling HQ H3 13369 have been treated under General Note 11P to reaffirm that goods classified under HTS 8471.70 would be considered originating under General Notes 11P and hence qualify as USMCA originating goods. Question is, can a PHCSO hard drive qualify? That seems like a very specific question.
Yeah, I think I would need a lot more detailed information about, how that hard disk drive is being put together, from what parts, from where, and there's really not enough information to answer that question here.
What is the order of review when calculating total tariff on a product of China? E.g., 1, determine HTS code, 2, identify general duty, 3, add the 301 tariff, 4, add the IEEPA tariff, 5, add the reciprocal tariff. Are there other tariffs we need to consider when thinking about China? Are there the ones I've listed, and or have I missed any?
Yeah, no, that's a good question. I mean, I think your customs brokers are probably on top of all this. They have a pretty good system on kind of tracking all the applicable tariffs. I think you start with the classification of the product. That HTS code uh, identifies first the normal duty rate that was in play before any of these tariffs were applied. Then you see to what extent any other tariffs might be relevant to that HTS code. So it can be 301, it can be IEEPA, can be reciprocal. There can also be anti-dumping duties, countervailing duties that could apply. So, yeah, I mean, you start with identifying how that product is going to be listed under the HTS code, um, and then just check what other tariffs might apply.
Yeah, I've heard some people talk about 145% tariff from China, but I mean, they stack upon each other, right? So depending on the product, that it may go beyond that.
Well over 145%.
Yeah.
Yeah.
Did President Biden impose tariffs by executive order?
Yeah. I think, his tariffs on the semiconductors, that was issued by executive order too. So, yeah. So, I mean, it started under, I guess, President Obama started the flurry of executive orders because, Congress at that time was not, passing any laws to get anything done. So that kind of triggered the wave of executive orders. So, it's Congress remains pretty gridlocked still. So, it seems, the executive branch has used these executive orders as a way to, bypass the gridlock.
As you mentioned, this has become a surprisingly bipartisan issue, at least from the executive office.
Yeah, I mean, I think that's the thing is that both Democrats and Republicans have used the executive order system to get things done. They may differ on what needs to be done with those executive orders, but the use of the executive orders as a tool of the executive branch, um, both parties have been very happy to use that tool when in office. And so far, the courts, Congress has not done anything to rein in that executive order power.
What is the current total tariff for steel products from China?
Oh, God. You have the 25% on the 232 steel. But the thing is, you've got a whole bunch of anti-dumping, countervailing duty orders that have a range of, duty rates. So, you'd have to figure out exactly which product is there, and then, which anti-dumping duty rate would apply. So, at least 25%. Then you've got the reciprocal tariffs, you've got the fentanyl tariffs. So, oh, God, I'd say at least 180 plus whatever anti-dumping, countervailing duties there.
Can you explain why an item might have a duty but not a tariff and vice versa? I have seen duty on some items but no tariff and tariffs but no duty.
I guess if you're referring to duties as like the normal duty rates, a lot of HTS codes had a zero duty, normal duty rate. So, that may be why you have zero, no duties on that. But tariffs, if it's a China 301, a fentanyl, tariff, and reciprocal tariff, those are tariffs. Those are also duties, but they're called tariffs because they're special tariffs that are being imposed. But duties and tariffs are interchangeable.
A local company has paperwork proving the seamless piping they bought from Thailand was substantially transformed there, even though the steel billets originated in China. But a blanket penalty has been issued against the company in Thailand since there were some irregularities with transshipment on other products. They are in the process with CBP, but are asking what's the best way to talk to the CBP in person to make their case so they are not swept along with the illegal activities of that Thai company. Any advice?
Yeah, no, I mean, this is an example where CBP is trying to enforce import shipments, and steel pipe is certainly a priority area of customs enforcement. So it does seem like CBP has already an investigation underway. They've enforced against some people, and that enforcement effort seems to have caught up some, collateral damage. People who are importing from the same, someone involved in that enforcement action, and now you have the burden of that importer trying to prove themselves innocent when customs is assuming they're guilty because of their other enforcement actions there. So it's a tough spot to be in, but it still can be done. Customs does listen, and as long as you can present a case sort of explaining why you are not part of that scheme that customs is enforcing against, you have a shot to kind of prove that your products that you're importing are not being part of the evasion scheme that customs has gone after.
Is there a chance to make your case in person, or is this something that's done?
Yeah, you can. I mean, usually the way it works is customs sends you a notice saying, "Hey, we think you're evading. We're rate advancing you, and we're charging you. You have to pay an extra X percent. Whatever duty rates are applicable." Um, you get a chance to respond and say, "Hey, look, we disagree with your proposed action, and here's why." So it's usually in writing. You can, ask for a meeting with customs to kind of explain in person what you, put down in writing. But generally, in the end, whatever you argue should be in writing so that you have a record of what your arguments are, and more importantly, how does customs respond to your arguments? Because they're ultimately going to be able to respond in writing. And if you still disagree with customs, you have a chance to appeal that to the U.S. Court of International Trade.
And we have a lot of questions left, and we're not going to have time to get to them all. I'll ask one last question, but Adams did agree to participate in an upcoming Ask Me Anything session that we will notify everyone of in the next couple weeks, where we'll spend most of an hour going through people's questions. So We had a lot of people come today, lots of questions as one might expect. So the last question that we'll ask today is if we are interested in reclassifying our products to a different HS code, how do we make that request with customs?
Yeah, so we help a lot of companies prepare a ruling request to customs, and so we'll help the company basically lay out, here's the product that we want you to address. Here's how it's made. Here's where the components are coming from. We're looking at country of origin. If it's just a straight classification, you can say, hey, look, we think, this HTS code is, what we think is the appropriate one, and here's why. Here's some other rulings that seem relevant where customs has looked at something similar, and this is why we think this HTS code is applicable or not. And customs can say, no, we disagree, or hopefully they say, yeah, we agree. Great reasoning, and they sign off and you're on your way. But sometimes they'll say, no, we disagree. The ruling you cited is not relevant. We think this other ruling is more relevant. Here's why we think that this other HTS number is the right one.
As I mentioned, our time is up. So I want to thank everyone for attending, and I want to thank you, Adams, for the information. I appreciate your willingness to take the time to share your knowledge and experience with us. This is very interesting. Thank you.
Thanks for having me. Really enjoyed it.
Great. We've created a resources page on our website that includes links to all the resources that we mentioned today during the webinar, as well as link to register for upcoming events to sign up for our Passages twice weekly email newsletter. So the email is located on the slide, or you can use your phone to use that QR code to get taken to that page. And we'll make sure to have Adams's contact information on there as well. You can reach out to him if you think he can be of some further assistance for you. In addition, please check out the Shipping Solutions YouTube channel, which is also listed on this slide. We've published a couple hundred short videos now discussing the basics of exporting and importing on this channel. It's growing very quickly in popularity, so check it out. And if you like what you see, please subscribe to the channel. It's having a strong social media presence in addition to having a strong blog that helps us attract high quality speakers like Adams to keep us all up to date on the world of international trade. So your support on that is very helpful. Thank you again, everyone, for participating today. Thank you, Adams, for your excellent presentation, and I wish that you all stay well. Thanks.